Welcome and hello everyone. My name is Gordon Feener and I am an attorney located in Boston, Massachusetts with a satellite office in Stoneham, Mass. During the course of this informational segment, I'd like to focus on the issue of attachments in connection with a collection of business debt. This segment is in a series of informational segments concerning commercial debt collection. Before I begin discussing the subject matter of this informational video, I'd like to briefly summarize my background. I have been in business as an attorney for more than 30 years, providing legal services with a concentration in property-related insurance claims and business debt collection. Prior to starting this office, I worked for approximately 20 years in the insurance industry, primarily in the property damage area. With respect to the issue of attachments, I offer the following for informational purposes and not as legal advice. A question that is asked many times by a business owner or a creditor is whether they can attach the property of a company or debtor that owes the business money. In general terms, an attachment of the debtor's property can take different forms depending upon the situation. One of the more common forms is a real estate attachment, which is commonly known as a pre-judgment attachment. To obtain a real estate attachment, the first step is for the business owner or creditor through its attorney to file a lawsuit against the business debtor, the party that owes the money. The second step is for the business owner or its attorney to request what is commonly known as a motion with the court, asking for the court to grant a writ of attachment against the debtor's real estate. The attorney will need to show that the lawsuit has a reasonable likelihood of success and that the debtor has no liability insurance coverage to cover the obligation or possible judgment. Once the attachment is approved by the court, the document is then recorded with the appropriate registry of deeds, which would affect any attempt by the debtor to sell, transfer, or refinance the subject real estate property. If the business debtor has no real estate but only has business property and or equipment, then the attorney for the business creditor can seek what is known as trustee process, which is effectively asking the court to grant an order preventing the business debtor from transferring any of its business property or equipment during the pendency of the litigation. To obtain trustee process, a similar procedure is followed in which the attorney needs to file a request called a motion with the court, again requesting that the court issue an order preventing or limiting the debtor from transferring, selling, or encumbering the subject business property or equipment. In the event that the business creditor is a construction company, a third option is for the contractor to file a notice of contract, formerly known as a mechanic's lien. Care needs to be taken in filing a mechanic's lien to ensure that all these statutory requirements are met, otherwise it may be ineffective. If you as a business owner are owed money by another business and are considering legal action, we would suggest that you begin by organizing your documents and records to support your position and contact an attorney who concentrates or focuses on business-to-business debt collection and creditor rights. During your initial meeting with your attorney, you should be prepared to bring with you key documents concerning the matter, along with possibly a timeline of the various events that took place to assist the attorney in evaluating your case and in determining whether to contact the debtor or, in the alternative, to draft a complaint to initiate litigation, along with seeking of attachment or trustee process to protect your rights. If you are considering your legal options against a business which owes you money, please feel free to contact the law office of Gordon Feener. For additional information, you may wish to visit our website at www.attorneyfeener.com. In conclusion, I'd like to thank you for listening to this informational segment and remind you that this informational segment can be considered to be advertising under the ethical rules. Any selection of an attorney should be a careful and thoughtful decision. Again, thank you for watching this video and have a good day.